Mr. Gardner, state your name.
Derek Gardner.
Judge, just for the record, I was just recently appointed. I've finally had a chance to speak with Mr. Gardner. I understand his impatience with this matter. He'd like to go to exam. I'm 99% sure I can get the video that we need to get prior to the exam. So we're asking to go to exam.
And Your Honor, I do see that on the unarmed robbery case, there's a media notice that was marked and previously sent to the public defender. That one will be able to get quickly. I see we received media just yesterday on the malicious destruction case. I'll get that marked and hopefully sent today. The issue is that I don't believe we have Mr. Killwell's appearance on file yet for that malicious destruction case.
So far, I'm not sure I've been appointed to that, but we'll see.
He's assigned, Mr. Levo's assigned to this one.
On the MDOP.
Yeah, I called all of his cases.
Selectman Davi Leba from Gardner on the MDOP matter.
Okay, well, what are we doing on your case
We're requesting adjournment order to receive discovery.
to get discovery on that one?
Yes, Your Honor.
All right. And on the case ending in 032, I'll adjourn the probable cause conference to the 9th, April 9th, 2026, 9 a.m. Bond on the matter will continue. You want to proceed that quickly to exam on the other one? You don't have all the discovery. You have the paper discovery?
I've got some of it. Judge, Judge, I will get it.
I know that, but if you don't have it, Mr. Gardner, you understand that that's not going to be the basis for an adjournment. And you'll just be without the stuff.
I don't understand what
What the judge is saying, if we set a preliminary exam and I don't get all the discovery, including the video, which you want to watch, the judge is still going to go to exam that day, even though we don't have it. That's the risk we take. I think I can get that, but you have to know that if you still want to go to exam. Is that your wish?
I mean, I want what's in the best interest of me being
Well,
just. I want justice, man. The video is justified.
okay, that's okay. Let's set the exam date and I will ensure that.
Well, he's going to need to.
Judge, I'm not trying to be difficult. I'm sure
You are. I mean, because you know what I do, and I'm trying to. He wants to make sure that he's got the exam. I'm just trying to make sure that he's going to have the discovery and what he wants,
That's what I want, Your Honor.
and that he wants to see it. That's my issue.
Right.
I'm just trying to let him know if you get to exam and you don't have it or haven't been able to watch it, you're not going to get an adjournment for that purpose.
I'd rather wait. I'd rather wait and further discover.
Okay.
Probable cause conference will be adjourned to the 9th. Same time as your other one, sir. April 9th, 2026, 9 a.m. Bond, let's get your other one.
have a second, Arjun. We're coming back. I will see you this weekend.
Don't have it yet, but I want to get it.
You see, I can do that.
Yes. So I got one right in the pocket.
Allowed to the people, Your Honor.
Brian Mullen, on behalf of Mr. Edie, Your Honor. Maurice, state your name for the record, please.
Maurice Edie. Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to an added count 2 of use of cocaine, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the.
Yes, sir.
That's my understanding. Well, Judge, is that your understanding, Mr. Edie?
Yes, sir.
Let's have him sworn.
Right hand, you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Help you God.
I do.
Thank you, please.
Maurice Edie.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Do you understand that?
Yes, sir.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand?
Yes, sir.
that? Still wish to plead guilty
Yes, sir.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed in advice of rights form, is that correct?
Yes, sir.
Question regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Sir.
And because you believe that you're guilty of this offense?
Yes, sir.
On the date of May 13, 2025, at the location of 1020 Whitaker Road in Ypsilanti Township, Washington County, State of Michigan, were you in possession of cocaine?
Yes, sir.
Used it?
Yes, sir.
Know what you were using was cocaine?
Yes, sir.
Sir, if I accept your plea, between the time I accept your plea and the time of sentencing, you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Okay. I'm not.
And have I complied with the court rule?
You have.
Court will accept the defendant's plea to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
May 7th at 10 a.m.
said May 7th.
Yes.
May 7th, 2026, 10 a.m. That's before Judge Washington. Bond will continue. All right.
Thank you, sir.
Thanks, Judge.
Assistant Public Defender with and on behalf of Mr. Palmer.
Is your name for me?
My name is Reese Palmer.
All right. I have before me two plea forms indicating that Mr. Palmer is going to plead guilty to two charges of retail fraud, second degree, the 1-year offense.
That is correct.
Right? Okay. Those are, well, on the one case, 123-1072, that's, I think, the stated count.
That's-
Right? We brought that one in.
That is,
And on the other case, that's an added count two, with count one being dismissed. There is an understanding that, and there's no other understanding. That's the court's full understanding of the agreement. Is
that's correct, Your Honor.
that correct, Ms. Gaines?
Yes, Your Honor.
All right, can I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Reese Palmer.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to two charges of retail fraud. Is that correct?
Yes.
All right. Now, those are misdemeanors punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than 2,000, that becomes your maximum fine. You understand that?
Yes, sir.
All right. Still wish to plead guilty to those charges?
Yes, I do, sir.
All right. Starting in the case ending in 1960 to an offense occurring on August 31st, 2025. To that charge, how do you plead?
Guilty.
All right. To that same charge contained in the case ending 1072, occurring on June 28, 2023. All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
You have any questions regarding any of those rights?
No.
All right, look at copy on the podium. Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No probation, no parole. I haven't had a ticket or nothing in 8 years, sir. These cases is 2 or 3 years old. I was in a bad place, sir. I was homeless, but now I'm in a better place. And I just want to get this behind me, sir, and get back home.
All right, we'll work on that, okay? All right. Has anybody promised you anything other than what's been stated today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, sir.
and because you believe that you're guilty of these offenses?
Yes, sir.
Okay, starting with the case ending in 1960. On the date of August 31st, 2025, at the location of 3825 Carpenter Road, that being the Meyer store. What'd you do on that date that makes you think that you're guilty?
I took a bunch of shirts, sir. I was homeless and I needed clothes.
And you tried to walk out without paying for them?
Yes, I did.
And these items you took, Meyer had offered for sale,
Yes, they did.
and you didn't have anybody's permission to take that, did you?
No, I did.
On the other case, on the date of June 28, 2023, again at the Meyer store at 3825 Carpenter Road in Pittsfield Township. What happened on that day?
I took some liquor, sir, because I was staying in a tent. I need to get warm. So I took a couple bottles of liquor.
Okay. And I think this one is actually on a prior offense. Had you previously been convicted in 2018 of a retail fraud? You recall that?
I don't know, sir. I was in a,
Let me ask it this way. You, previous to 2000, you had been convicted of retail fraud before that, right?
yes.
Okay. All right. Mr. Peterson, if I accept your plea, and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your pleas. You understand that, sir?
I understand that, sir.
Okay. And the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand that, sir.
All right. Counsel, have there been any other promises, threats, or other indicia which have led to this?
None from the people?
No, thank you, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, sir.
I will, in the case ending in 1960, I will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be April 8, 2020 for me. And
May we address bond, please, Your Honor?
one moment. And on the other case, I'm also going to refer him to probation for a pre-sentence investigation and report. Sentencing will be April 8th, 2026, 9 a.m.
Street.
Yes, that's about. Where's he? Christian, where are you living now?
I'm on Ecorse Road, 111 Ecorse Road in Ypsilanti,
It's not
Michigan.
his paperwork that we submitted, his address,
Yeah, no, I got it.
but he
Oh,
has his own
in
it's
township.
place.
Yes, I have a place, sir. And I'm in a good place now, sir. I'm just trying to move on with my life. And like I said, I didn't know these cases was behind me. I would have had them taken care of before I came, before this even got to this matter.
Okay, and
He's receiving Social Security now, Your Honor.
I'm aware of Mr. Peterson's bid. And so, Mr. Peterson, let me ask you, if I let you out, you're gonna make sure to get over to my probation department?
Yes, I will, sir. I'll be there.
And you're gonna get, because both of these cases are before me.
Yes, sir.
Gonna get yourself back here?
I'll be back here, sir. On court date, I'll be here.
Hold on, is your balance okay?
Any response to the bond modification in the future?
No, Your Honor.
And just like that, bond granted. This is huge. The judge is balancing risk versus rehabilitation, giving the defendant a chance to return home. But make no mistake, one wrong move from here, and that freedom disappears instantly.
I'll grant the motion. Mr. Peterson, I'm gonna let you go home.
Thank you,
Right.
sir.
I'm gonna set your bond in each of these cases at a personal recognizance, $5,000. And I'm ordering you don't go into any Meyer store in the state of Michigan. You hear me?
No, sir.
All right.
Thank you.
Thank you.
That it?
Yeah.
Thank you, Mr. Gardner.
Yeah.
Hello.
Good morning, Mr. Peterson. Can you state your name for the record, please?
Walter K. Peterson.
Thank you.
Your Honor, I'm requesting one more adjournment of this PCC. We're trying to reach a resolution. I believe we're very close. There's just some final things I'd like to get some answers to before we move forward.
All right. April 9th,
That works for me, Your Honor.
2026, 9 a.m.
And Your Honor, if I could address bond briefly. I know Your Honor has allowed Mr. Peterson to be released to treatment. He would like to do that. Unfortunately, I know the order that we submitted with the people had a stipulation for a GPS tether on there. I'd be asking for him to be released without the tether. He does not have phone or any financial ability to get one right now.
That the only thing holding him up from going?
Hold on, Mr. Peterson. Yes, Your Honor, I believe that is the issue, is he would need to be placed on a tether, and I believe he needs a phone to be able to do that.
Have we received that communication from you? Don't have any scale indicating that.
I will follow up with the jail then and we'll clarify.
Send that and then I can consider it.
Thank you, Your Honor.
All right. Thank you.
Asking, can I address him? I can't just address him without it.
What do you have to say?
So, Sammy, trying to get up off of that stuff and reemerge back and trying to get me a job.
He knows that. We'll do that once we get you out to treatment. Okay. Thank you, Your Honor.
It's so.
Hi,
Well, it's good to have you back.
thank you.
Your name, ma'am?
The Chardonnay Sanders.
Thank you. You need an adjournment?
Yes, please, Your Honor, to making sure I have all discovery and then to share that discovery with my client. Additionally, my client is.
The 9th work for you?
I'm sorry?
The 9th work for you?
Yes, it will, Your Honor.
Probable cause conference will be adjourned April 9th, 2026, 9 a.m. Bond.
Well, my client's asking me to make a bond modification argument, Your Honor.
Okay, go for it.
Okay, thank you. My client's currently charged with 2 cases that are very serious. She understands that, but those are allegations. She'd like me to relay to the court that she's lived in this county her entire life. She has some children that she needs to ensure that are being taken care of. During this time, she has been working on her case service plan for her neglect and abuse case, and she's doing well. She does not have a job at this time, so the bond amount that in each case is a financial hardship for her. She's willing to do a GPS tether. She understands that she needs to come back to court, and she has family in the area that she could stay with and support. So we're asking to lower the amount to a PR if possible and or a 10% component, Your Honor. Thank you.
Front from the people.
And I would ask bond saying she failed to appear on the child abuse case in this court. Second charge, she got picked up and she was here before you was assault, very probably harm, murder. She allegedly stabbed her mother's girlfriend in the arm, causing a lot of damage.
My client tells me that she had.
Police Garlight. And here's the turning point: bond denied. Why? Because the stakes are completely different. We're talking about a violent allegation, a stabbing. In cases like this, judges prioritize public safety over personal circumstances. Tough, but that's the reality of the system.
Phone stolen from her, and that's why she missed her court date, Your Honor.
Okay. Thanks for letting us know. Given all those circumstances, I'm not going to reduce her bond. Her examination is coming up, and we can certainly address it at that point in time after the testimony is heard. Motion for bond reduction is denied.
Thank you, Your Honor. Thank you.